Welcome everyone to the Links CBRC training on disagreements with the school, parent options on special education. My name is Lily and I'm a parent advocate with the Community Parent Resource Center. Today we'll talk about what you can do if you don't agree with the school about your child's education services. Disagreements can feel overwhelming, but you have clear rights and multiple choices. By the end of the session, you'll understand the tools available and feel more confident in navigating them. Here's the roadmap for today. We'll cover informal options like calling IEP meetings and IEP reviews, then move into formal processes like mediation, state complaints, and due process. All of these options exist because of IDEA, the Individuals with Disabilities Education Act, which guarantees every child with a disability a free and appropriate public education, or FAPE. As parents, you're an equal member in the IEP team and your voice matters. Disagreements happen for many reasons. Maybe your school offers fewer services than you believe your child needs. Maybe you feel your child isn't making enough progress. Sometimes there's disagreements over placement, whether your child should be in a general education classroom or a more specialized setting. Evaluations can also be a sticky point. Perhaps you feel the school's assessment didn't fully capture your child's needs. The important thing to remember is disagreements are common and do not mean you're being difficult. They mean you're advocating for your child, and that's exactly what your job is and what IDEA supports. Start with the simplest approach, an IEP team meeting. You have the right to request one at any time. In this meeting, bring your concerns in writing and be as specific as possible. For example, instead of saying, I don't think my child is learning, you might say, I have noticed my child still struggles to read grade level words despite 6 months of reading intervention. You can propose solutions, like adding a specific evidence based program, or ask to trial a new strategy for a set period. Request that these discussions and any agreements be documented in the IEP notes. This helps ensure follow through. If the dispute is not resolved, a facilitated IEP meeting may help. A neutral facilitator keeps the team focused and helps manage conflict. They don't take sides, they help everyone communicate better. Not every district offers this option, but if it's available, it can be a powerful way to break through barriers while avoiding more formal disputes. If you've tried informal methods and things still aren't resolved, don't give up. IDEA gives you formal dispute resolution options designed to protect your child's rights. These include mediation, state complaints, and due process complaints. These might sound intimidating, but they are there to ensure fairness and accountability. Mediation is voluntary and free. A trained mediator helps both sides reach an agreement. Unlike facilitated IEPs, mediation results in a written, legally binding agreement if you reach a consensus. Many parents find mediation less stressful than going into a hearing and more effective than repeated IEP meetings. It's a great way to find common ground without escalating into a legal battle. A state complaint is a formal written complaint filed with your state education agency if you believe the school violated special education law. For example, by failing to provide services in the IEP, you can file a complaint. The state investigates, collects evidence, and issues a decision, usually within 60 days. If they find a violation, they can order corrective action. This is a strong option if the issue involves noncompliance with the law rather than a disagreement about what's best. Due process is the most formal step. It's essentially a legal proceeding where you and the school present your case before an impartial hearing officer. This option is often used when there is a deep disagreement about identification, services, or placement. Because it's legal, many parents seek an attorney before filing. It's more time consuming, but it can result in a binding decision that compels the school to act. After you file a due process complaint, the school must hold a resolution meeting within 15 days. This is one more chance to solve the issue without a hearing. Sometimes these meetings are successful, especially when both sides see the stakes of moving forward into the hearing. In a hearing, both sides present evidence, bring witnesses, and make their case. The hearing officer then issues a legally binding decision. While hearings can feel intimidating, remember they exist to ensure your child's right to an appropriate education is protected. If you disagree with the hearing officer's decision, you can appeal to state or federal court. This is rare, but it's an option if you believe the decision was wrong. At every stage, documentation and preparation are key. Keep detailed records, emails, reports, meeting notes. They can make all the difference. One of your most powerful tools is knowledge. Schools must give you a procedural safeguards notice. Read it. It explains all of your rights in plain language. And remember, you don't have to do this alone. Parent training and information centers like Links CPRC provide free help. We can guide you through these processes, help you prepare, and even accompanying you to some meetings. Here's how the process flows. Start informal with calling an IEP meeting and stating your concerns. If that doesn't work, escalate to facilitated IEP or mediation. If problems continue, consider a state complaint or due process. Each step builds on the last. The goal is always to resolve issues as early as possible while protecting your child's rights. To wrap up, stay involved, know your rights, and seek support when needed. You are your child's best advocate. For more information, check out the Parent Center Hub, Cadre, and of course, Links CPRC. Thank you for being here and for standing up for your child's education.